In a proceeding pursuant to CPLR Article 78 to review a determination of the Commissioner of the New York State Department of Correctional Services dated June 1, 1999, which affirmed the determination of a hearing officer dated April 4, 1999, made after a Tier 3 disciplinary hearing, finding that the petitioner violated prison disciplinary rules. The appeal is from a judgment of the Supreme Court, Dutchess County, dated April 25, 2000, which annulled the determination and directed that all references to the offense be expunged from the petitioner's records. The Supreme Court improperly concluded that a determination affirming a disciplinary determination following a Tier 3 disciplinary hearing should be annulled because the hearing was untimely. Contrary to the Supreme Court's determination, the first extension of time to complete the hearing, granted pursuant to 7, was valid. The 14th day following the writing of the inmate misbehavior report was a Sunday. Thus, the grant of an extension on the 15th day was timely. See General Construction Law, Section 25A. Maldonado v. Coughlin, 150, Appellate Division 3rd, 692, 693. The Supreme Court also improperly determined that the appellant failed to obtain another extension to complete the hearing. This issue was not raised by the petitioner in the administrative appeal or in his petition, and therefore was not properly before the Supreme Court. Contrary to the husband's contention, there was sufficient evidence to support the family court's finding of the existence of aggravating circumstances. See matter of Riley v. Riley, 254, Appellate Division 2nd, 361, Family Court Act, Section 827. The order of protection is thus modified to include this finding in compliance with Family Court Act, Section 842. In a special proceeding pursuant to Executive Law, Section 63, paren 12, inter alia, to direct the calling of a special meeting of the unit owners of the Hyde Park condominium to elect new managers. 1. Johnson appeals and others separately appeal from an order of the Supreme Court, Dutchess County, dated August 8, 2000, which, among other things, granted those branches of the petition which were to direct that a special meeting be called to elect a new and independent condominium board of managers of Hyde Park condominium, and that all records, books, and financial accounts of Hyde Park condominium be turned over to the petitioner. In this case, it was ordered that the judgment dated September 21, 2000 is modified on the law by deleting the provisions thereof, enjoining those persons from voting at unit owners' meetings, and enjoining those persons from participating as members of the Board of Managers of Hyde Park condominium, and substituting therefore a provision enjoining those respondents from continuing the fraudulent and illegal acts that they were found by the court to have committed. As so modified, the judgment is affirmed insofar as appealed from, without costs or disbursements, and it is further ordered that the order dated December 14, 2000 is affirmed insofar as appealed from and reviewed without costs or disbursements. The petitioner met its initial burden of demonstrating its entitlement to the relief sought, and no issues of fact were raised in opposition. Accordingly, the Supreme Court properly summarily granted the relief sought in the petition. It is undisputed that the appellants failed to appear at the framed issue hearing to determine whether the alleged offending vehicle was insured at the time of the accident. Since no appeal has come from the order, we dismiss.